me timata tātou e tēnei o nā kōrero me ki. Hoi anō mihi tonu ki a tātou e kua piri mai. Piri mai mai tata mai tāwhiti, nei mai hara mai whakapiri mai. Te tuatahi mā kuka tuku tonu ki a tau tonu tēnā manaki ki rungi a tātou. Hoi anō, mai e te tipua, mai e te tāputa, mai e te kawiariki. Mai e tāwhiwhi atu ki a koe e rongo whakairia ki runga, ki a tau mai tarangi Māori e Haroumi e hui e tā ki e. Hoi anō, tēnei mihi nui ki a koutou. Tēnei Te Mana Mātāpono Matatapu e miana ki a koe tēnei te wiki tūmati iti. Nei mai hara mai, whakatau mai, whakapiri mai ki tēnei tō tātou nei kōrero, ki tēnei tō tātou nei Wānanga me ki i tēnei haura o tā rānei. Nō reira, nei mai hara mai, whakatau mai, whakapiri mai. Ko tāku whāti tēnei mihi tonu ki a rātou i nā mate o te wā. Nā mate mai te hiku tāno tonu ki te pōneke nei, ki te whanganui ātara, a whakawhiti ki te waipaunamu, ki wharikauri, ki nā mate ki runga tonu i te pai o maumahara, tēnei e mihi ana ki a rātou e nā mate haere atura. Ka huri anō ki a tātou nā waihotanga, mauri ore ki a tātou, mauri ore ki a tātou. Nō reira, i tēnei wā, i tēnei kōrero kua puri mai, i kōrero pāna ki nā āhuatanga te tikanga Māori me tēnei mai e ki mai privacy nei. Tō kaupapa, tō tātou nei kaupapa, i aha tēnei me te privacy ki tā te Māori titiro. Ki tā te Māori titiro. Nō reira, e mihi nui ki a tātou. Ki runga tunu i te papakata nei, ki a Carwyn, tēnā Dr. Carwyn Jones, tēnā i piri mai, hei mātanga, hei kai kōrero me tēnei kaupapa mihi nui ki a koe e Carwyn, e te pāpa, e te Pūkenga, e te mātanga, e mihi nui ki a koe, e te whanaunga, mihi nui ki a koe. Tāno ki a mātou ki kōnei. Hoi anō ki runga tunu tēnā whakatau, ko te me nui, me tuku atu ki a koutou, ko wai e nei i noho ki runga tunu i o koutou pau whakaata i tēnei wā. Nō reira, ko mā kou tēnei, ko PJ Devonshire tēnei, ko au no Wairarapa, ko Tararua te maunga, ko rua mahanga te awa, ko Wairarapa te moana. He uri mokapuna no Wairarapa kātō, no Rangitāne, no Kahonunu. Nō reira, tēnei e mihi ana ki a koutou. Ka tuku atu te rāko ki tapu nei ho, e noho ki tapu taha ki a whakamana ko wai. Kei a koe, Joanna.
Hai.
Pepi hā.
Pepi hā. Ko aku tātai hono, kei ko Te Mana mā Ingarangi. No te waiponamu, no oto tāhia hou. I whānau au ki oti poti, ko mōhua taku wahi moto hake. Kei poneke a hou e noho ana inaene. Ki te mana whenua o whanganui a tāra, tēnei o ka mihi. Kei te Mana Mātāpono Matatapu a hou e mahe ana. Ko Joanna Hayward tōku ingoa. Tēnā koutou katoa.
Kia ora, Joanna. Tuku turaka ki a koe e kaua.
Tēnā tātou. Ko Carwyn Jones tōku ingoa, he uri ahau no ngā te kahununu ki te wairo, i tupu ake ahau i ahuriri, e noho ana ahau nei kei te whanganui ātara, he Pūkenga Matua ahau o te hotaka Ahunga Tikanga, kei te Wānanga o Raukawa. Reira, tēnā tātou.
Kia ora, tēnā koe Carwyn. Me huri au ki te reo Pākia i nai nei, the whakaata me reo rua tēnei kaupapa. So kia ora tātou again, welcome to everyone who's come in. And just again, introducing ourselves as your panelists for today. Me and PJ Devonshire, Pou Ārahi, Te Mana Mātāpono Matatapu. Nō reira, awesome to have you on board and to have Carwyn with us as well. A couple of little housekeepings. If you can see your screen, there's a Q&A button and a chat. If you want to ask questions, put them into the Q&A, please. The Q&A, not the chat. We'll be focusing more on the Q&A. but the questions will be coming through near the end of the session. Near the end of the session, I think we're all wanting to listen to Carwyn and his whakaaro, pāneki tēnei koutou, the thoughts around Tikanga Māori, privacy, and a few other things, the reflections from the case of Waka. So agree again, ngā mihi kia koutou. So that's only a little bit of housekeeping I think we have. I tēnei wā ai ka tika tēnā mihi tonu ki te atiawa, kia te atiawa Ngāti Tō, Ngāti Raukawa, koutou te Wānanga Raukawa Carwyn, mihi nui kia koutou. 0100 Wānanga, if you're interested in doing and seeing what the Wānanga has to offer, 0100 Wānanga, kia ora koutou. Kia ora koutou. Tēnei wā ka tuka atu tēnei o nā rāka ki tō tātou nei rangatira, tō tātou nei kai kumihana kia Liz McPherson, kei a koe Liz. Kōrero.
Tēnā koutou katoa. I te rangatira Carwyn, tēnā koe. I rau rangatira mā, tēnā koutou. Ina iwi e huhui nei, aku nui, ahurahi. Nau mai, haere mai ki te wiki tū mataiti. No tamaki makaura ahau, I whānau mai au I runga I a maunga whau, ki te taha o te Waitamata. No Irene, ko te mana, ingarangi, rātou ko haina o ku mātu tūpuna. Kei whanganui atara a hau I noho ana, ko Liz McPherson tōku ingoa, ko te Mana Mātāpono Matatapu tuarua e nei. Tēnā koutou, tēnā koutou, tēnā koutou katoa. Welcome from me. My name is Liz McPherson. I am the Acting Privacy Commissioner, and it is my pleasure to welcome you on behalf of the Office of the Privacy Commissioner to this session, which is the pinnacle of our Privacy Week. So welcome to Privacy Week. And I, like you, am really looking forward to hearing from our panellists. As Aotearoa New Zealand's privacy regulator and part of the Crown, OPC has obligations under Te Tiriti o Waitangi to partner with Māori, Whānau, hapu and iwi to bring Te Māori privacy perspectives to privacy. Now, while the Privacy Act does not have a treaty clause, these obligations are reinforced by a new requirement under Section 21C of the Privacy Act 2020. This section requires the Privacy Commissioner to take account of cultural perspectives on privacy when performing any statutory function or duty and in exercising any statutory power. That means that the Privacy Commissioner will have to be able to answer the question that Justice Gwyn asks in the judicial review of the Waka case, which is, what did or does tikanga require in these particular circumstances? And as the Justice also notes, it's well accepted that tikanga Māori is part of New Zealand's common law. So to be able to answer that question, what did or does tikanga require in these particular circumstances, OPC is partnering with Mātanga Māori, Māori experts in tikanga, including takuta Carwyn and other fields, to understand what privacy means from a Te Māori lens. Now, that's not about translating the Privacy Act into Māori terms. It's about starting from a grounded understanding of tikanga and how it applies Māori concepts of privacy and the protection and safe use of personal information. Then we can work together to understand how the two frameworks can interrelate. Now, at OPC, we're at the beginning of our journey, and we're really eager to learn from real-life experiences like the Waka case here today. It's a jumping off point for us. It's a way of exploring what things really mean. Like you, I'm looking forward to listening to takuta Carwyn regarding the application of a tikanga to this particular case, and also, Carwyn, to your views on tikanga and privacy in general. I'm going to join the rest of the office who are listening to this session. So from me, again, nā reira, tēnā koutou, tēnā tātou katoa, and kia pai tō wiki tū mataiti.
Tēnā koe. Liz, thank you for that. Nā mihi kia koe. Opening up, we've got the chats going along. Mihi nui kia koutou. Again, if we have questions into the Q&A box, but they'll be looked at nearer to the end. And so, mihi nui kia koutou. Te ahua nei, rua rau, ono te kauma rimo o koutou. Mihi nui kia koutou ko puri mai, mihi nui kia koutou. So really good to have a good turnout for the session. So again, the session around Tikanga Māori and Privacy reflections on the High Court. So one of the places we want to start with in terms of this role, in terms of this webinar and this kōrero, is just to start in the place of the role of the Office of the Privacy Commissioner. Now, what was our role? What was our part in this? And then we'll move into more of an idea into Carwyn's role and those other things that are happening. So I'll just hand over to my colleague Joanna, who's the General Counsel, General Counsel for the Privacy Commission. So Joanna, kei a koe.
Kia ora, PJ. Tēnā koe, Carwyn. Kia ora, everyone. Yes, I'll just jump in here and take up a little bit of time just to talk about the Waka proceeding as context for our then leading into a kōrero with Carwyn. It's really interesting that the theme of Privacy Week 2020 is privacy as the foundation of trust. And that's a theme that's really resonated with OPC's pandemic response work over the last 2 years. And the Commissioner at the time in his blog talked about the importance of maintaining trust and confidence being critical in the times of an emergency response. And we also saw the United Nations Special Rapporteur for Privacy talking about this. He said that while the priority in the pandemic is to save lives, that fighting COVID and then respecting human rights, including privacy, those two things aren't necessarily incompatible. And in fact, trust of citizens that their privacy is being taken into account helps to build confidence and willingness to proactively support the measures that need to be taken. Now, what's interesting is that observation of the Special Rapporteur was cited in both of Justice Gwyn's decisions that we're talking about today. And trust also was a real theme for both the parties to the proceeding. And what we saw here really was the role of both the Privacy Act and Tikanga, both working through the tensions and the diverging questions that arose about trust in the pandemic context. So this was a judicial review about access to data about unvaccinated Māori at really the peak of the vaccination drive. And access was being sought under what's really the break glass emergency exception in the Privacy Act and in the Health Code. So we won't be able to do justice here to all the interesting dimensions of the case or the full range of the parties' concerns and legal arguments. We've got more detail on OPC's website in a case note, and you can see OPC's submissions, and there are links to Justice Gwyn's decisions on it. But just to quickly take a step back and remember what it was like at the time. It's not that long ago, but it feels like a long time ago because things were very different then. We were in that heightened state of the COVID response. Delta had just arrived. Tamaki Makaurau, Auckland, was in that prolonged lockdown, but was about to come out of lockdown. The health system was focused on the urgent rollout of the vaccine to the entire country and with multiple doses. And Māori vaccination rates were materially lower, around 20% lower than other population groups. And so there was work going on to try and address that disparity. So the judicial review represented the first opportunity for a judicial interpretation of what the serious threat to public health exception means in a pandemic. And part of the Commissioner's decision to intervene in the proceeding was there were synergies with our COVID response work, but also with our emerging Te Ao Māori strategy. So it was the public interest in really testing the privacy framework under these pandemic conditions. And I just would like to acknowledge the OPC team who worked on this. This included our outgoing Commissioner, John Edwards, our current Commissioner, Liz McPherson, our external advocate, Ben Keith, and our OPC team, including PJ and our senior legal advisors, Amy DeJoux and Amy Williams, and with support from across the office. So the Commissioner's intervenor submissions were directed at the approach to take to pandemic decision-making about data. So we were talking about how do you think about this rather than the substance of what the decisions should be. But at its heart, this proceeding was about a Māori service provider seeking urgent access to data about unvaccinated Māori across Tikanga Māori, the North Island, for the vaccination outreach. And it was about what health data the Ministry of Health was able to share for that purpose. So the party here was Te Pou Ārahi Limited, which is the commissioning agency for Whānau Ora, and it's called the Whānau Ora Commissioning Agency, or WOCA for short. And Whānau Tahi is the information systems provider for WOCA, which is acknowledged to have impressive capability from a technical perspective and from its personnel with handling data. So WOCA and the ministry entered into an information sharing arrangement in relation to the vaccination outreach, and WOCA requested personal information about unvaccinated Māori, so their contact details, vaccination status, and their vaccination booking status for Tikanga Māori, the North Island. So the ministry could share anonymised data that mapped areas with unvaccinated communities, but declined to share the identifiable data about individuals who weren't enrolled with a WOCA provider. And this was because of systematic concerns about the divergent views of Māori from the ministry's engagement and from the potential risks to public confidence in the health system. And because of the availability of possibly less privacy intrusive options for handling this. But there was a lack of consensus about whether it would be appropriate to share this individualised health data about Māori. So the ministry's decision-making engaged the Health Information Privacy Code, which is made under the Privacy Act. And this has limits on disclosing health information without a person's authorisation or consent. But there are some important exceptions. And in particular, the health code does allow for information to be shared if an agency believes on reasonable grounds that it's not practicable in the circumstances to obtain authorisation, or where there's a serious threat to public health and the sharing of the information is necessary to prevent or limit that serious threat from arising. So where those exceptions are made out, there is a discretion on an agency to be able to disclose information without specific authorisation. So both the parties here agreed that there was a serious threat, but what the parties didn't agree on was whether it was necessary to prevent or lessen that serious threat to share the individualised data with WOCA. And so that was really the key focus of the evidence, the submissions and the argument. Now, the Privacy Commissioner put forward an evidence-based approach to dealing with these questions, and the court agreed that there needs to be a proportionate and evidence-based approach, both to whether the sharing is going to be effective. So if the information is disclosed, is it going to help to reduce the serious risk that's presented? You also need to look at the anticipated adverse consequences. What are the potential downsides of the sharing? Could it cause more harm than good? And thirdly, are there other available and better options in the circumstances? And that was a real question here, whether there were other options to sharing the data with WOCA when thinking about the possible downsides and impacts on trust. And the ministry had therefore identified these two other options, disclosing the anonymised or the mesh block data to look at doing that first, or secondly, sharing smaller sets of data with locally based organisations, which might help build trust and confidence in using that information. But the issue here was that there were gaps in the evidence-based assessment of whether those measures would have been equally effective to sharing the data with WOCA in light of the urgency and the serious threat. So, for example, would locally based organisations have the necessary technical capability to handle the data in the way that Whānau Tahi does? So in light of this urgency from the COVID environment, the Privacy Commissioner submitted that the data sharing decision doesn't have to be a perfect solution, but it's whether the disclosure is necessary to address the risk in an effective way. And the court here accepted that the decision isn't a counsel of perfection in this environment. Rather, it's what's reasonable and consistent with the Privacy Act and the Code to do what can be done within that tight time frame and with the evidence of the risk increasing over time. So in the end, the court accepted that the premise of the Privacy Act and the Health Code is that disclosure is permissible to address serious risks. And that being the case, the decision to disclose under the Health Code was therefore a discretionary one for the ministry to make. And so the discussion then turned to the exercise of that discretion and whether there were additional obligations that pointed towards disclosure, such as the right of Māori to the highest attainable standard of health. And this is where we come to what did Tikanga require? And there was evidence before the court from Tikanga experts, including Carwyn, that there is a highly prized taonga in health that has primacy in the context of the pandemic. And Lady Moxon's evidence was also cited that if there is taonga in data, that taonga must give way to life and health.
So that just gives us some context around the role of our Office of the Privacy Commissioner in terms of that kaupapa. And it's when we moved into what did Tikanga require in terms of this case. And again, this is one example of Tikanga Māori with privacy and what we're doing here in the Office of the Privacy Commissioner, wanting to do this journey and understand what Tikanga Māori means for us in terms of privacy. So I'll hand over to Carwyn now. Carwyn, just again, what was your role? Talk to us, how to wāhanga ki tēnei mahi. So what was your role in this, in the case and some of your thinking as an introduction, then we'll move into some questions. Kia ora.
Kia ora. Thanks for that summary of the proceedings too, Joanna. I hasten to add that I'm not a privacy law expert at all, and I also hasten to add that I wouldn't describe myself as an expert in tikanga either. I very much see myself as a student of tikanga and probably will for a long time. But my role here was in terms the kind of background and experience I do have is thinking about tikanga in the context or the interface with the New Zealand state legal system. And so I had been asked in this case to provide some expert evidence on, what tikanga might say in terms of the application of the rule here and the law here, and how it might inform the way we think about privacy and the protections in this context.
Kia ora rā, nā mi kia koe, and I think that's one of the key things in this context, and as we move forward, we'll go a bit wider into more of a general kōrero. But again, Joanna's mentioned some of those others that were part of it, Lady Tureiti, Moxon, nā mihi kia koe whā, and others that were also part of that kaupapa. Koutou i Whānau Commissioning Agency, mihi ana kia koutou hoki, Ministry of Health, mihi ana kia koutou. One of the things that Justice Gwynn asked about, spoke about in terms of the case, and again the question as it was brought up was, now what did tikanga require in these particular circumstances? What did Tikanga Māori require in these particular circumstances? Justice Gwynn, she also reaffirmed, which is a really interesting point, that Tikanga Māori is part of New Zealand common law. Tikanga Māori is part of New Zealand common law. And we know that the likes of Judge Joe Williams has spoken about this in the past. There are others that have. And of course, in thinking in terms of our own, all of our tipu, all of our rangatira, Papa Moana Jackson, and a lot of the kōrero that he'd had, e mihi nui tonu ki tēnā o ngā taonga, Papa Moana koutou, I te rā wiki. Via June Hookie, mihi nui. And so these discussions have been going on for quite some time, and to have that come through. So in terms of Tikanga Māori, and how did you describe Tikanga Māori, Carwyn?
Well, tikanga Māori is, I mean, if we really boil it down, it comes from the word tika, or correct or right. So tikanga is really just the correct or the right way of doing things, the collection of practices and knowledge that reflects the right way, the correct way of behaving, and involves, I think, is inherent within it an element of justice as well in that aspect. So it really applies to a whole range of Te Ao Māori. So all aspects of Te Ao Māori are governed by tikanga, from the very mundane to the highest endeavours of people, and so I always think about tikanga as incorporating a system of law. Ani Mekaere would talk about tikanga as the first law of Aotearoa. And so we can think about it as certainly as incorporating a system of Māori law, and it's a little bit, as you would expect, it comes from a different context than the common law, than the New Zealand state legal system, and so it works in quite different ways, and also has some substantively different rules that apply as well. So one of the things that I think is really important to recognise is the way in which tikanga is much more a kind of principle-based system of law than, say, the common law, which kind of focuses on defined legal rules in a different kind of way. So when we think about tikanga Māori, we can think about some key principles or values like whanaungatanga, mana, tapua noa, utu, aroha, kaitiakitanga, manakitanga, those kinds of ideas, those principles, which really determine how you respond or how you act in particular ways.
So there's a lot of discussion. Mr. Mihi kia koutou te chat ka ki te a koe mohi. Kaue po he, this is the Tairāwhiti kahununu version of tikanga. And so this is one version, and as our father would tell us, kei ia hapu ia iwi ia morai, tōna ki kawa tōna ki tikanga. So just wanting to ensure that my whanaunga kāwana is really safe in that area. That this might be the wairoa to wait it up of you if we haven't got anyone from Hiratonga here though. So ngā mihi mo tēnā. So a lot of the kōrero we've had in the past here our kāwana is that LAW law versus LORE law. A lot of those sort of kōrero come through in the past as well in terms of tikanga versus law, common law, that area. One of the things that did come out in the case, this one to have a look at, was a discussion on taonga. And I think we mentioned earlier, and so did Joanna mentioned a bit earlier, about the primacy of health, or the life of the tangata. Now, orangatanga, where orangatanga sat, the order of the person, where that sat in terms of what we can and can't do. And so, again, Lady Moxon spoke about taonga. We talk about data as taonga. That data, if that's the taonga, then the data had to give way to the health and all of those sort of things. So maybe in an opportunity for you to elaborate a little bit, how do you see taonga, data as taonga, come? And how we see that.
Yeah, so I mean, I think you can certainly think about data as taonga and being, if we think about taonga as something which is highly valued, and in terms of the way in which the Waitangi tribunals talked about it in the Y262 inquiry, is that that has a kaitiaki associated with it, and so of course there's different kinds of data, and there'll be different kaitiaki and different ways in which we understand that data as taonga. One of the things that I thought was really important that came through in this case, and certainly that I was made sure to raise in my evidence, was to recognise that that health is also a taonga, and so often when we find this is the same in the state legal system or under tikanga Māori, often there'll be a balancing that needs to take place to think about how different rights are balanced with one another, or how different interests are protected. And here, where we have two taonga, the taonga of data and the importance of needing to protect those, to protect that data, but when you balance it alongside thinking about, well, what you also have the taonga of health, of the well-being of of a community. And I think that when we're thinking about a tikanga framework which has such an emphasis on whanaungatanga and relationships and the maintenance of whakapapa and the continuing and survival of our communities, that recognising that health is also a taonga that needs to be protected and ought to be given primacy and weighing up those considerations about how to make that assessment of what protections apply to the data, which is also a taonga.
Kia ora. And I think that was one of the key things that came through, these, I don't know, maybe this taonga, and they are all taonga, and what is the kaupapa, what is the promise of these taonga? I think, as we know, I think you used one of our whakatauaki, no roti te tai tokarahi ha te menui o te ao he tangata e kōrero tēnā, e pāna ki tēnei kaupapa. And so mihi nui ki a koe Carwyn. Just in terms of data and taonga, I just wanted to acknowledge, and I think some of them may be linked into Te Mana Rauranga, Dr. Tahu Mā, mihi nui ki a koutou, ko koutou nei mahi. Koutou Matua Rahui Pāpa tēnā, koutou Te Tātiwi Leaders Group, mihi nui ki a koutou hoki. And the mahi that's being done. As was said earlier in our piece, as we started off, and Liz mentioned, this is one of a few sessions that we're having, maybe not as a webinar, but sessions that we're having in terms of the Office of the Privacy Commissioner, Te Mana Mātāpono Matatapu, and reaching out to those mātanga that may help us, including, I know some are on board, Muhi Mā, from within this rohi as well, so we can get to understand more about what it is, what Tikanga Māori is. Not for us as the office to make the statement, this is Tikanga Māori in terms of privacy, but so that we can begin to understand, so when we move forward in our mahi, we've got a framework that we can work through. So just in sort of heading to those areas there, Carwyn and Joanna. So the question was, what does Tikanga require in these particular circumstances, was the question that Justice Gwen mentioned in terms of this case, the Waka case. I think we've had, is there anything else you want to add in terms of what the Tikanga required? And I know we've seen there was some discussion around things like at the time, hui of our iwi and others.
Well, I mean, just that I would say that, I would say that the application of tikanga is always a highly contextualized process. So it's really important to consider the full range of circumstances and think about what are the best ways of expressing those key principles or values in the particular circumstances. So I think it was really significant to note that the context of this case did involve a time of real urgency in terms of thinking about trying to bring those Māori vaccination rates up, and it was happening at a time too when there was talk about sort of moving down the I think it was moving down from the traffic light restrictions or moving Tamaki Makaurau coming out of some further restrictions that they were under at the time. So there was a real urgency of trying to ensure that these vaccinations were as high as possible before those restrictions lifted. And so that all informs part of the context. That then gives that weight to thinking about putting in a tikanga framework, putting the collective at the front of that, ahead of what are genuine, genuine both in a Te Ture Pākehā sense, but in a Tikanga Māori sense, concerns and need to protect data as well. But because of the particular context, that very much, I think, from my perspective, shifted the weight towards thinking about what's necessary to fulfill those tikanga around whanaungatanga, around mana and tapu of a collective, around manaakitanga and kaitiakitanga, ensuring that a community and the well-being of the community is protected.
Mihi nui kia koe, Carwyn. And yeah, it's all of those, it's some of the stuff we're talking about there. And again, we've seen it and we've been around it, and we said quite regularly, I suppose, some of those I suppose, clashes of worldviews. I'm looking at some of the chat that's coming through and some of the questions, and how we begin to manage that mahi in terms of those things. So I just want to sort of lift it up a little bit now in terms of the wider view of the Privacy Commission, or privacy itself as a kaupapa, as a concept in terms of a Western view. And as I said earlier on, and repeat again, the Office of the Privacy Commissioner, no, we're not wanting to become the people that say this is Tikanga Māori. That's not our role. We are part of the Crown, we are an independent Crown entity, and so kaupapa Māori would need to come from a place of kaupapa Māori. Ko te mea nui ko te ao Māori tērā. And so we're thinking about that and how we can do these things. So in terms of, and you'll mention some of those kaupapa, Carwyn, but in terms of this thing of idea of privacy in a general sense, more general sense, Māori with privacy. So, e nei te pata, hea tēnei me te privacy nei ki tāta Māori tituru. So what does privacy look like from a Māori worldview? From a Māori, and again, I know I need to, my whanaunga from Waitangi, this is one of many kaupapa, many kōrero we're going to be having whānau on the chat. So, so those of you might be from the Taihawauru, kaupapa no tērā. But so I'm just, again, putting that for my whanaunga to Carwyn, that a view, and we're looking for views. Nō reira, ki tā Carwyn ki te rokia.
Kia ora. So, I mean, one of the things that is, I think, interesting and what seems like a bit of a clash between Te Turipaka and Te Ao Māori on this matter, and Tikanga Māori, is that, the privacy in a Western law sense is often really centred around the individual and the rights of the individual to protect their privacy and their data. Whereas, of course, the Te Ao Māori has a much more collective focused approach. And so when we're thinking about what that might look like, it doesn't mean that there aren't any rights to privacy, but it means they sit in relation to other rights of the wider collective as well. And one of a couple of key concepts that I think are really important, that I would see as being really important in a tikanga framework of thinking about how you understand privacy, would be the kind of principles of mana and tapu. And because I think you can think about, well, what kind of protections would you need to put in place to ensure that the mana of people is protected in terms of thinking about the disclosure of information or the management of data. And I think I see tapu as playing a really important role in there, much in the same way we often think about things to do with the tinana, with the body as being very tapu, and things that are closely associated with the body. I think you can also think about some data, and particularly health data, as having that extension of tapu as well. And so that requires that there's a very deliberate approach and process for engaging and working with things that are tapu, but in this case thinking about data in that way. And what it also means is the other thing I think is important in thinking about this context is Tikanga Māori doesn't say, well, there's just a free-for-all, everyone's information belongs to everyone else and there's no protections. Actually, there are protections that are built in, but through mechanisms like the principle of tapu and mana, recognizing that there is autonomy around your tinana, around things that are associated with that, and I would extend that to some data as well, and that there are, even if you might understand it as being in relation to other rights of a broader collective, of the whānau or the hapu or the iwi, then that might shift the weight, and when you're dealing with questions like came up in the Waka case, might shift the balance in terms of where you prioritise the the rights of the collective over the rights of the individual. In a tikanga Māori sense, they're all seen as being connected and part of the same bundle of rights. But it doesn't mean that there are no restrictions on that use. You still need to ensure that you are treating that that information, that data, for the purpose of which you are wanting to access it. You are dealing with it carefully, deliberately, and sensitively. And those are all built in to principles of tikanga Māori.
Kia ora, I suppose just on that, Joanna, one of the things for those that might not know the Privacy Act is the 13 privacy principles that we have. And so I know our past Commissioner, Privacy Commissioner John Edwards, and I think John maybe watching in, or some of the staff from the UK, kia koe, John. So again, we talk about the privacy principles being principle-based, much like kaupapa Māori. You take in terms of the principles, Joanna, privacy principles?
That's right, PJ. That, we also in the Privacy Act have a principle-based approach, which isn't as prescriptive as some other types of legislation. So I do wonder if we have a bit of an opportunity here, Carwyn, where we've got two principle-based systems. And I think what we're interested in exploring is the flex within the privacy principles framework to make connections with the tikanga framework and look for resonances and commonalities there.
Kia ora. Yeah, no, that's let's get to that's right, Joanna. That's what we're trying to do in terms of this kaupapa whānau. I see that we have some questions coming through. I might just across just to one more area, one more discussion with Carwyn, and then see if we can answer some of those questions. Some of them are quite long, so if we've got some one-liners or so, we quite take it to pai, mihi nui kia koutou, tuku mai, tuku mana pātai. If we can't answer them then, we'll endeavour to do something as we go forward in terms of our mahi. But one of the things we talk about, and again, I suppose I need to give my conflict of interest as being an ex-Te Mana Raukawa student in Kaiko. and the way that we said at Te Mana Raukawa, we talked about, and also Dr. Ranginu Walker and others like that, one of the things was mātauranga Māori, and where it came from. And one of the things we talk about is building off our pūrākau, or our oral traditions, and looking into those pūrākau, those oral traditions, to say to us, what are the lessons in there? What are the lessons that Maui can teach us? What are the lessons that Kupe could teach us? What are the lessons that those around could teach us in terms of what we need to do and how we could bring them forward? And I think it's a different view to then going, we don't want to be starting with privacy and going, well, okay, let's start at the Western world. No, if we move back to where we are, to that question, that statement, tēnei mea te kupu privacy ki tā te Māori tituru, not, so from a Māori lens, what does it look like? And one of the things that we talk about is pūrākau. So any pūrākau, any oral traditions or kōrero that you may know from our tipuna, from our, not from our kaharunu tipuna, but from te ao Māori. Carwyn?
Well, interesting that you say, what can Maui teach us? Because I think within the pūrākau about Maui, there are certainly lessons about a whole lot of things, but information about how we might think about privacy as well. So if we think, one example is thinking about, well, in fact, this is a kind of bit of a theme throughout the kind of Maui story cycle, is the way in which Maui often builds up trust with his tipuna, and so we can think particularly about his kuia who gave him her jawbone so that he could fish up the ika Maui, and the reason why, first of all, we might think about, well, this might be in a kind of metaphorical sense, what does the jawbone represent? Well, we can think about it certainly as representing kōrero, and so we can think about why that tipuna is willing to share and give up that knowledge, that information, that kōrero to Maui, is because he has built up trust with her, by engaging with her, by demonstrating actually the skill set that he has. And so one of the things that I think we might learn from that in terms of thinking about the way in which protections around data and privacy might work is to think about, well, it's important that people who have the requisite skills and knowledge and are going to manage this, who have the requisite skills to manage that knowledge in a way that's appropriate and effective, are the ones who are trusted with that knowledge and information. But even if we think about the story of Maui's birth and how he, he's obviously separated from his mother and brothers and whānau for a time, and is raised again by a tipuna. And when he returns to his whānau and finds his mother, how does he demonstrate his connection and his place in the family? Well, he recites his pepeha and the names of his brothers that he heard his mother recite while he was in the womb. And there we see again a kind of the value of information and the careful protection of that information and the way that it gets then put to use as well. And so we can see that his pepeha being carefully managed and then used and revealed. And so I think that also speaks to ideas about how to manage and protect data as well.
Can't wait, Carwyn. And I think, I really enjoyed that kōrero on terms of Māori and his tipuna, his kuia in terms of the jawbone. I know one of the kōrero that is close to maybe my heart and close to the wāhi here in Whānau is the kauwairunga te kauwairaro, which is an example of, I suppose, privacy, confidential in a way that, not as you said, not everybody was privy or attended or were part of the Wānanga, and there were things that needed to happen. There were things that would happen, and our tipuna would observe the child and those sort of things as they're growing through, and depending on whakapapa and a whole lot of lines. So really, so thank you for mihi nui ki tēnā, that kōrero there. I've got a couple of questions. So I'll just bring a couple up. I know I've got 9 then. Sorry if I don't get your questions, but and it's just really mihi nui ki a koutou Māori mā. Now I see a lot of our whānau coming from across the way, and not just our Māori, but to all of those that have come on board. Here's one. I've got a question. Here's an interesting one that I think we'll look at it in terms of a bit of privacy as well. So Tama, nami kia koe tō. In relation to Carwyn's comments around having autonomy over one's body, what autonomy do whānau have over the body of their loved ones during a post-mortem? Maybe not quite a privacy question, but do you have a question on that, or maybe that's Carwyn?
Well, I mean, again, if you're thinking from a tikanga perspective, that the authority or the autonomy in relation to the tūpāpaku, it doesn't, it doesn't sit with the state. However, there may be factors in a tikanga framework where as we've talked about in terms of the waka case as well, there may be factors where there's a collective interest in the tūpāpaku sitting somewhere else for a time. Now, those are real important questions of tikanga to try and figure out where you have that balance there, because you're dealing with a very tapu process, and thinking about, well, how do you best recognize that and give expression to that while also reflecting the kind of kaitiakitanga, manaakitanga of a community, perhaps. I mean, I think that, and that's why it's really important to recognize the tikanga is always applied in a highly contextualized way. there are, yes, those kind of key principles are really important and foundational, but the particular circumstances will guide you on how those ought to be applied, and it will depend on the various parties involved and their relationships, and what's trying to be achieved as well. So all of those factors need to be really taken into account, looked at carefully as you weigh up how to give expression to those tikanga.
Mihi nui ki a koe. Another part I see aroha no ngā te awa, mihi nui ki a koe pa. One of the questions is about, that, and I think it came through in some of the cases, and also in some of our other thinking, this idea around the crown, this side of the whare, I suppose, Joanna and I, and iwi, and the kaitaki of information, rangatira about information, heading maybe some of those treaty conversations that we have and obligations that we have, and where does that sit amongst us? Maybe not so much in the waka case, but just as a whakaro, as a kōrero.
Yeah, well, I mean, I would think, this does seem to be speaking to very much a Tureiti context in terms of thinking about, well, what's the role and authority of kāwanatanga in relation to tino rangatiratanga, and I think the default position always ought to be that that tino rangatiratanga means that Māori would have control over their taonga, including their data and information. And so that would be the starting point for me. Now, there might be, again, aspects of thinking about how that then relates to processes of the Crown and the kāwanatanga side, which Māori wish to engage with, and there might be questions of how to work out some of the practicalities of managing those data through those processes. But actually, I think you start from the fundamental point of tino rangatiratanga means Māori control over taonga Māori.
Kia ora rā, mihi nui ki a koe. We've got some questions coming into the chat there, and one of them, mihi ki a koe muhi. So a question that we will have a look at. On the marae, we conduct tikanga in accordance to the marae's ability to carry out that in accordance to their mana. Do we carry out tikanga with the same understanding of what it is, of what it's for in the privacy space? And so how do these things work together? How do these things happen there? So whakaaro, kōrero, mihi nui ki a koe muhi.
Yeah, I mean, I think that's a really important point, and again, that really speaks to the importance of the context, and to understand, and one of the things that I think in the privacy context that's really important to understand is that that the purpose of the use of the data is relevant. So as I say, just because you have a tikanga-based response where you might shift the balance between the individual's right to privacy and the collective's right to access information, it doesn't mean that information is just willy-nilly free for anyone to use. Tikanga itself provides a framework that sets the parameters around what's appropriate use, around processes that might need to be followed, around thinking about what the limits are, and the purpose of it is a really important part of the context and understanding all of those parameters as well. So and thinking about the ability to discharge that function and purpose, and how best to maintain the mana of everyone involved, really. So those are all, and that's why I know I'm sort of repeating myself here, but it's why context is so important in thinking about the application of tikanga, because there are lots of factors that need to be taken into account and weighed in terms of thinking about what is the best expression then of the tikanga.
And I think we've spoken about that as well, haven't we, Joanna, in terms of the privacy act?
Yes, it's the value of a principles-based approach, isn't it, Carwyn? it is very context dependent, and you can look at what is presented before you to pull in the various elements that you need to work through. And we're very familiar in the privacy context with that concept of purpose also, that's the real driver through the privacy discourse.
Kia ora, Joanna. So I know there's another question. That's one of the things, you know, we've spoken about earlier on in terms of the mahi that we're trying to do. And when we need to do this mahi as the Office of the Privacy Commissioner, so we can understand in one of the Privacy Act, the Section 21C, you know, it talks about ensuring that we take a cultural perspectives on privacy. And so that's the kaupapa of why this is, you know, alongside our treaty, you know, our rangatira Liz spoke about, you know, that the obligations of the Te Tiriti or Waitangi, but really needing to understand. So when we do take into account some of these kōrero, some of these things that may come through, that we know we are coming from a place where we are thinking about tikanga Māori, kaupapa Māori, all of these things in terms of what we'll do. Some of us about collectives versus individuals. And we know this is a kōrero, but I think, and you know, in terms of you know, that thing, you know, there's, if you look at the word Whānau and Whānanga, I know we've done this sort of thing in the past, and in the middle was an A and U, O, surrounded by Whānau, surrounded by Whānanga, surrounded by whakawhanaungatanga, these sort of things. And so that's how we are, you know, when there was tino rangatiratanga as a people, but we also needed it as a collective, and mana was paramount. I think in terms of mana and tapu, you know, in some of that thinking, this might be a bit controversial to some of us, controversial out there to some of us, but he whakapapa tōna mea katoa ki tā Māori, ne? So Māori, in the Māori world, everything has a whakapapa. Everything has a whakapapa to something, to an atua of some sort, or to whoever, there's a whakapapa there. And so one of the questions I was wanting to put out, maybe leave this as a kaimo te hine naro, kia koutou pera kia koutou moima, but you know, maybe Carwyn's got a kōrero for it. If we were thinking of atua Māori, we're thinking of privacy. This kōrero around, tū matiti, matatapu, huna muna, ira kuku kato. Who would be the atua that we may compose kara care to ask for tautoko there? Carwyn, who do you think might be?
Well, that's a good question. So, I mean, there are different ways of probably approaching that. In some senses, you know, I think there's a question around the different types of data and information are probably connected with different atua. But I do think, and depending on your traditions, you might think about tāwhaki, or you might think about tāne, who getting the kite mātauranga, and I think that, you know, because really there's something there about knowledge and information and knowledge systems that is really important to think about in terms of privacy as well.
Kia ora, ka pai sai hea, tēnei kōrero, tēnei whakairi ki runga. Hei kaukau kia mā koutou hei Wānanga tēnā kōrero, so mihi nui kia koe. We're coming to the end of our session, and mihi nui kia koutou. I know there's a number of questions that are still unanswered, and we still have a number of questions unanswered as well as Te Mana Mātāpono Matatapu. And as we continue to work through this heat with this journey of ours to coming to a place of understanding what this means for us in terms of Te Ao Māori, and then how, in the role that we have in our roles in terms of the Privacy Commission, that we can ensure that we are coming from a place when the decisions have been made, when the court has been made, that takes into account, you know, tangata whenua, Te Ao Māori, our people here. And so mihi nui kia ki Carwyn, again, just to mihi to my whanaunga wairo ki te wairarapa, mihi nui kia koe, so I won't mihi too much, but mihi nui kia koe iho. Again, 0800 Wānanga, if you're keen to listen to Dr. Carwyn Jones some more, 0800 Wānanga people, mihi nui kia koe, kia koutou, koutou no, o tēnei rohi, koutou o Te Awatarana Whānui, he mihi nui kia koutou, there's mai tunu ki tēnā kōrero mo te kahu o te raukura, mihi nui kia koutou, ko tau tēnā ki rongi tēnei wāhi. I runga tūni te whakaaro ko puta mai te kōrero tōku whanaunga nei, mera pia ko tāne te atua pia, ko tāne te atua. Ke kare ke tēnei kia whakakapi i tēnei hui, i tēnei Wānanga, no reira, tēnei te kareke, mai e te tipu, mai e te tāwhito, mai e te kawiari ki, mai e tāwhito ki a koe e tāne. tāne whakapiripiri, tāne te Wānanga, tāne te Waiora, tāne Nui Ārahi, taonga mai te whaiao, taonga ki te ao marama, Haroumi e hui e tāiki e tēnā tātou. Mihi nui ki a koutou, kia pai te wiki tūmata tini. Kia ora rā.
Kia ora.